Ms. Schultz, are you able to hear me okay?
I can.
Thank you. And Mr. Williams, are you there?
I am, Your Honor. I'm almost there.
All right, thank you. And then on the Samsung device, is your name Glenn Price?
Yes, sir.
Okay. All right, so we'll go on the record now in People versus Glenn Price. This is file number 255467. If I could have both counsel put your appearances on, starting with the prosecutor.
My name is LaDonna Schultz. I am acting prosecutor in the city of Crawford. I'm sorry, county of Crawford.
Your Honor, Jesse Williams. I represent Mr. Price, who's present on the Samsung.
All right, thank you. We're on the record today for purposes of a status conference in this case. Mr. Williams, can you tell me where things are at from the defense side?
Certainly, Your Honor. We have, Ms. Schultz and I have been in communication. We do not seem to have a resolution at this time. The only real issues that we discussed, there really aren't any prior bad acts on that we're addressing. I did not file notice of rape shield exception because there isn't that issue in this case. The only issue that really hangs out there is the elected prosecutor in the county of Crawford is a witness in this case and was consulted prior to the charge. And there's also a transcript. The district court records everything, but they won't give me the recording. I do want to get, I think it was when he was rearranged before Ms. Schultz took over, the prosecutor made comments about the case on the record that's also a witness in this case. So she is a witness. I will subpoena her. I don't know if that'll turn into an evidentiary issue, but that's the only road bump I see going into trial right now. It's pretty straightforward. I don't even think, I think 2 days we could try this case.
Okay, so Mr. Williams, how much time would you want, or how far in advance would you want the court to set this for trial?
Can we get like a mid-February trial, or is that a possibility?
I think so, probably February or March for a 2-day. So that would be an adequate amount of time for you to be able to be prepared.
Yeah, March. I guess March would be better than I think I'm going to take some time off in February. If we could put it in March, that would be good.
Okay. All right, Ms. Schultz, do you agree with the time frame setting the trial in March and with the duration being 2 days?
I agree that it shouldn't take more than 2 days. My question, Your Honor, is when is your trial docket? What part of the month?
Correct. I know.
So it's the second week of the month, Ms. Schultz.
Okay.
So the first full week of every month is my motion week. And then the next week after that is my trial week.
Okay, that because I have trials scheduled in my court, both in February and March, but we start our trials the third week of the month, so the second should work.
Okay, all right. So what I will do is set this for a 2-day jury trial. We'll shoot for March. I can't guarantee. The clerk was just telling me that my trial schedule for February is full. I don't know if any have been set yet for March, so we'll shoot for March for a 2-day jury trial. I will set this for a final status conference about 30 days prior to the trial date. That will be the plea cutoff. So counsel and Mr. Price, to the extent that there are any further plea discussions, that final status conference would be the last day to enter a plea. Once we get past that point, the court will not accept pleas to any lesser charges. That will also be the motion cutoff, so to the extent that we do have any evidentiary issues, and I appreciate you raising that, Mr. Williams, so that I kind of have a heads up that may be an issue here. But to the extent that there are evidentiary or other motions, in limine, that final status conference is the motion cutoff, so any motions would need to be set for hearing and filed no later than the date of that final status conference. I will send out a scheduling order that reflects these dates, and then you'll also get notices of the date and time of both that final status conference and the trial date. Mr. Williams, anything else that I can address for your side today?
Two things, Your Honor. One, may we appear for the final status by Zoom? And two, I know I should know these dates. I know March is kids' spring break. If that is a conflict, if Ms. Schultz is amenable to it, can I send a stip to set it in April if I have to? I'm just asking.
Yeah, so if the parties, if when we send out that trial date, if the parties have conflicts, they need to notify the court immediately. I usually stack trials, so if I get at that final status, yeah, I'm less likely to grant an adjournment the later it is, because then I'm wasting court time. So
I'll do it within the week. As soon as I get the notice, I'll do it immediately.
Okay, and then yes, I'll note for the scheduling order, Mr. Williams, that the court's approving appearances by Zoom for the final status conference.
Thank you.
Ms. Schultz, anything else I can address for your side today?
No, Your Honor, I think I'm all set.
Okay, sounds good. Thank you. You're all free to disconnect at this time.
Thanks.
All right, and Mr. Adams, who is your attorney?
Jason.
Mr. Thompson. He is in a different court right now, so we're just waiting for him to connect and get started. Just let me know. Jason's Mr. Adams, go to the podium, please. On record. And versus Richard Michael Adams, file number 255414.
Here, welcome back to the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant Richard Adams. Your Honor, I apologize for the late appearance. I was on Zoom court with Judge Hunter, just concluded. If I could approach, we do have a police sheet in this matter.
Okay, thank you. So the plea agreement indicates that Mr. Adams would be pleading guilty to one count of possession of methamphetamine for dismissal of the other two counts. Is that correct?
Yes, Your Honor.
Ms. Coke?
Yes.
Mr. Adams, have you had an opportunity to speak with Mr. Thompson about this plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Mr. Adams, are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to count one, that is a felony that carries with it a maximum possible penalty of up to 10 years and or $15,000 fine.
Yes, sir.
With that in mind, what is your plea to that charge?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights,
Yes, sir.
and you understand that you're giving up and waiving all of those rights and you will not have them anymore.
Yes, sir.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody forced or threatened you with anything to get you to give up your rights?
No, sir.
You don't have an automatic right to appeal the plea that you're making today. You have to do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone promised you anything other than what we've talked about here in court about this plea agreement to get you to plead guilty?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to this crime because you are actually guilty?
Yes.
Back on March 15th of this year, 2025, were you present here in Crawford County?
Yes.
You were here in Crawford County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it?
No, sir.
Ms. Pope, satisfied with the factual basis?
Yes.
Mr. Thompson?
Yes.
Counselor, either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No.
No.
Are you both satisfied that the court has complied with statute and court rules and statements?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Adams, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll meet with the probation officer for a pre-sentence report. Ms. Pope, anything further we need to address here today?
No.
Mr. Thompson?
No.
All right, thank you. That's all for today, Mr. Adams.
Thank you.
You seen Mr. Clock, Mr. Lewis, or Mr. Stein?
Clock and Lewis are both lodged.
Oh.
Isn't that Mr. Trush's?
He texted me, he just wanted to let me know.
All right, so this is Mr. Lewis and Mr. Clock walking in right now.
So, Mr. Clock, you want to come up to the podium, please?
He's not set till 9:45, and I just usually would for here.
On the record in People versus Caleb Clock, file number 255, court 42, the record should reflect Mr. Clock present here in the courtroom today. If I could have counsel make your appearances on in this case.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Caleb Clock. Sorry, Your Honor, I'm going through my files. I have a plea sheet on this. If the prosecutor could state the plea for the record.
Your Honor, this is a violation hearing.
Yeah.
The underlying case that's the basis for this violation is still pending in district court. He's not scheduled for his preliminary exam until January 13th. He does have a probable cause hearing next week. I would just recommend an adjourning violation.
I'm sorry, that's correct, Your Honor. Yes, Mr. Clock would intend to enter the plea in district court when that's up. So we'd ask to adjourn that until that.
Okay. Mr. Clock, do you have any questions about how we proceed in this case?
I just have one thing. The preliminary exam got changed to the 27th of January.
Okay.
I have paperwork for it.
All right, so we'll set this for a hearing in February.
Yeah, unless
I suspect we'll be before the court sooner than that on sentencing. So maybe we can address it.
Okay. All right, so I'll just set this for a hearing on the same date as the sentencing hearing once that's set.
okay.
All right, thank you.
Thank you, Mr. Clock, that's all for today. Mr. Lewis, if you'd like to come forward, please. We'll go on the record in Chico versus Eric Lewis, file number 2559493. The record should reflect Mr. Lewis is present here in the courtroom today. Thompson, how did we want to proceed on this case? What's the status?
Your Honor, there is a plea offer at this point. It's not the original plea offer because the defendant ran the prelim, but the current offer would be that if Mr. Lewis pled to 2 counts of RNO as a half second, which would make them 3-year offenses, the prosecutor would dismiss counts 3 and 4 and the additional potential official status offenses.
Scope, is that a correct statement of the offer?
It is.
Mr. Lewis, have you had an opportunity to speak with Mr. Thompson about the plea offer?
Yeah.
Do you know whether you would like to accept that plea offer?
Can I ask a couple questions real quick before I accept or deny or whatever?
Sure.
One is, am I looking at jail time or prison time? Can I know like a time frame reference? I don't care if ballpark, anything like that, jail or prison, it doesn't matter.
Mr. Thompson, did you run any?
No, I know the guidelines, Your Honor.
Oh,
You know what I mean? The guidelines should be like 5 to 24 or something like that. But I'm actually trying to seek help, like, like rehabilitation services of some kind, whether through drug or alcohol. I just did a long time in prison, so I feel like maybe like some type of break me back down to society thing would be more beneficial than going back to prison due to me, the circumstances of prison, alone and how long I just did or whatever. So I'm seeking something like that, you know what I mean? And the second thing I would like to say is during the prelim, it's not on the record or the docket why it was adjourned, and per law and policy that they're supposed to put that on the docket, and they went past my time frame for the prelim. It doesn't matter how it's added up. They have 7 to 14 days to hear me on the probable cause, and then 5 to 7 to hear me on the prelim, and they went past that.
okay.
So I don't know if that affects anything. I know due to law that's supposed to be taken into account. I was supposed to be given the Weston remedy due to that, and I was not given anything. I was just denied everything in court.
Supposed to be given what?
The Weston remedy,
What's that?
where dismissal or dropped in misdemeanor charges, Your Honor. This is in People versus Crawford, People versus Weston.
Okay, if they miss a date, you just, everything just gets dismissed?
No, it's up to the court's discretion on whether it gets dismissed or it gets dropped down to misdemeanors. And that's everything I've read, and that's as of 2025 law that's on our little computers in the thing. I just wanted to bring that up.
Well, maybe you have an argument. I don't know whether those cases are applicable here or not. So I guess you got two questions here. Number one, your question about the sentencing. I don't really know anything about you. I don't know anything about your circumstances. I don't know anything about the facts of what happened in this crime. If you were to plead guilty today, you've been through the process, it sounds like. So we would have a pre-sentence report where I would get all that information about you, your background, your past criminal history, what happened in this case, all of those different types of things, the guidelines. That all goes into my decision about what's an appropriate sentence. So sitting here today, I don't have any clue whether probation, local jail time, prison, which one of those options would be appropriate. So I cannot tell you what your sentence would be today, other than it would most likely be within the guidelines. In terms of I can't make a ruling today about the effect of any delay of your prelim. If you want to challenge that, you absolutely have the right to do that. You would need to do that either through your attorney or if we're going to waive counsel. But in any case, if you wanted to challenge that, if you believe that you're entitled to a reduction in charge or a dismissal of charge because of something that happened in district court, that would need to be filed as a motion. I would need to hear that motion and make a decision about that. I can't just off the cuff make a decision here today.
So one more question. You guys, I haven't been in court in a very long time. You know what I mean? And I don't really know nothing about like these type of proceedings, but they don't offer like a county cap no more.
That's up to the prosecutor. I mean, I don't get involved in sentencing negotiations.
Oh, right. Well, my lawyer told me that the courts don't even offer county caps anymore.
I never offered a county cap. That was never anything.
No, I'm saying like he's basically saying like they don't even do that in courtrooms anymore. Any type of county cap. The last time I was in court was like 2014 or something like that. And you could get county caps in that year. You know what I mean? And since COVID, a lot of things have changed. That's why I was asking.
I don't know what you mean by they. You say they.
Or just courts in general. Courts don't offer caps no more, I guess. That's the basic question.
I've been a judge since 2013. I've never heard of a court having a policy of some kind of county cap.
I mean, it's not, I don't think it's policy. I don't really know if it's a policy or any type of law, but I've got a 12-month county cap before. That's why I asked. You know what I mean?
To me, that's something that would be negotiated between you and the lawyers or
Right.
the prosecutor.
I
don't ever agree to.
I don't want to plead guilty, but I'll plead no contest.
Go.
I don't have an objection to that, but I don't have a police report. If the court has them in the file, the court could use that and I would not object. I believe it meets the elements if the court wants to review it.
Were you intoxicated when this happened?
No, I was off my meds and I was sick and I was on like NyQuil and Dayquil and stuff like that. And like, I really don't have any proof of this besides being sick when I came to the county jail. Like, I really wasn't in the right state of mind when all this happened.
Your Honor, I have a file copy of the police report. I would ask if I could give it to the court could review it for sufficiency, but ultimately that one without my notes on it be memorialized in the court file.
I have a blank one.
Oh, I'd ask the court to use Mr. Havens if that's possible. Thank you.
You know, you can tell that like I wasn't in the right state of mind by a couple of the statements. One, they told me to sit in a chair, and for some reason I didn't understand, or I thought it was a typo when I first read it, where not to cuss in the courtroom where it says I ain't saying shit. I didn't even know they actually told me to sit in a chair. So like I said, when I read the police report, I'm like, what? That don't even make sense. But apparently I really did say that. So that's, you know what I mean? That goes to my state of mind. Like, it don't even make sense why I would say that because I've been cooperative up to that point. And then another thing, I didn't even know what day it was.
Okay.
You know what I mean? Like,
Well, I think all of that would provide a basis for no contest plea in this code. Would you agree?
I would agree.
All right, so
If the court's satisfied, I don't have any.
no, I think I'm satisfied. There's a basis for no contest. So, all right. So you wanted to go forward with that plea agreement today then?
yes, Your Honor, I'll go forward with it.
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Are you currently on any kind of probation or parole?
I'm on parole currently.
Okay. So you understand that any sentence that you would receive in this case would be served consecutively, in other words, back to back with a parole violation?
Yes, I understand this.
And you also understand that you would not be entitled to any jail credit with the parole status.
Yes, I understand.
And by pleading guilty to resisting or obstructing as a second habitual offender, the maximum penalty that you could face for each of those charges would be up to 3 years. Do you understand that?
Yes, Your Honor.
With all of those things in mind, what is your plea to those 2 charges today?
No contest.
Now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court or any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading no contest.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you can only do that by leave. That means that you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
Just threatened basically for prison time.
You've been advised of the consequences.
No, basically I was told I was getting prison no matter what happens in this situation.
Okay. Are you, all right.
Mr. Lewis, are you referring to legal advice about possible sentences the judge might give?
When I talk to him about anything, he says that this would normally be like a 90-day type thing or whatever in a county jail. All he does is basically tell me that the whole courtroom and everybody just wants me to go to prison. So I'm just ready to get it over with and get going.
Okay. So it's Mr. Thompson's job to tell you what he thinks the likely outcome of your case is, right?
Yeah, he's basically like, it doesn't matter what the outcome is, what the pleas get dropped to, it doesn't matter. So,
Okay.
yeah.
Wouldn't you want him to tell you what the worst case scenario is?
I mean, it
Fully
just-
understand.
Yeah, I mean, yeah, I understand that, but it just doesn't make sense. You got people in the county jail with drug charges, massive amounts of drug charges, gun charges, which is a mandatory 2 minimum, and all types of other things that are getting county jail time. You know what I'm saying? I know somebody that just got caught with 2 ounces of meth and has a rap record longer than mine, and he's a known drug dealer, and he just got 7 months in the county jail for 2 ounces of meth and just nothing. You know what I mean? Like, so I know, like, if he's saying that, then, you know what I mean? Like, basically, I feel like, I mean, I ain't got no other choice. It doesn't matter if I go to trial or not. And I know you guys might not understand a lot of things about prison, but I'm gonna get a flop regardless because of the level I'm going to and the things I'm gonna be end up going back to. So it doesn't matter. It doesn't matter.
Okay. All right. Has anybody promised you anything other than what we said here in court today?
No,
Is it your own free choice to enter this plea?
I mean, yeah, I guess, yeah.
Okay, well, I don't want you to guess. It either is or it's not.
I mean, yeah, it is.
Okay. All right. Ms. Koch, have you reviewed, and I'm going to refer to Crawford County Sheriff's Department, report number 2512733. Have you reviewed that report?
Yes,
Do you agree that the information contained within that report would provide a factual basis for a finding that Mr. Lewis is guilty of 2 counts of resisting or obstructing a police officer?
yes,
Mr. Thompson, have you reviewed that report as well?
I have.
Do you agree with the factual basis?
I agree it provides a sufficient factual basis, Your Honor.
I need to read through this for a second. Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on the record here today?
No,
Mr. Thompson?
No.
Ms. Coke, are the people satisfied that the court has complied with statute before rule in the taking of this non-contest?
yes, Your Honor.
Mr. Thompson?
Yes.
All right, Mr. Lewis, the court finds that your plea is knowing, voluntary. I'm going to mark and admit that police report that I previously identified as Court Exhibit 1. I've reviewed that. The court finds that the information contained within that report would support a finding that you are guilty of 2 counts of resisting or obstructing. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You'll meet with other report.
Mr. Haven.
Meet with Mr. Haven for a precinct report. You'll have a chance to review that and go through that with your attorney before the
Sentencing. Your Honor, may I ask what 2, I guess, what 2 times am I pleading guilty to?
Well, you pled no contest.
No, I understand that, Your Honor, but I'm pleading guilty to 2 counts. I mean, does it matter? Does it matter what counts, or like, is there specific counts that I'm pleading guilty to?
You're pleading no, again, you didn't plead guilty.
No, I mean, no contest. I mean, is there 2 specific times in the police report
Counts
to which
1
I'm,
and 2,
which I'm actually pleading guilty to?
your support, you pled no contest, the court is finding you guilty of resisting or obstructing with regard to. Deputy Clark.
Okay. Thank you, Your Honor.
Oh. Oh,
That sounds right.
Or at least that's where he was the last time.
Yes, because we've been having all kinds of problems because I'm not trying to interrupt the court.
no, you're.
And then Mr. Harris should appear from Sheriff Sheldon. I don't know if it's a jail or.
They're trying to make us use this
Mr.
video
Truce,
chat app.
is Mr. Cyan,
With
is
Roscommon
he
Jail.
in Roscommon?
Yes, Your Honor. He is still in Roscommon's jail. I met with him there Monday, maybe.
Okay.
It was either late last week or early this week, but I can't remember.
And this,
Let's take it. So, Mr. Truce, we don't have Roscommon connected yet. And so I don't know if you just want to stay on the line or how you want to handle that. You had a writ prepared.
I just want to make something right.
Would the court like me to call over to their jail?
Yeah, if you would, that would be great. It does look like
So if I could
we did have a
take
writ.
an earlier
Mr. Cyan prepared.
She's just- She said she was sending an amended one of these over, so we may have to send it again. My client is just interrupting. She'll be out there. Morning, Your
It's
Honor.
early, like,
I have a scheduled conflict at 10.
Yep, if you want to bring her in, we can.
Yeah, I'll grab it.
On the record in People versus Shelby Sunday. This is file number 255436. Counsel for your appearances on.
Eric Hogan, on behalf of the people.
Thank you, Your Honor. Jody Oak, appearing on behalf of Shelby Sunday.
Ms. Phil, how do you want to proceed in this file today?
My client would be accepting an offer to second offense DUI. She's accepted into the sobriety court program in Sheboygan County, which is her residence. And I have that to court today.
Sure.
And I've talked to the prosecuting attorney out there. She has been accepted. I know these little memorandums are difficult in terms of the boxes we're supposed to check because every county wants them done differently. So we didn't really check the boxes. So whatever boxes that court needs us to check or this court needs us to check.
And she told me she's gonna amend it too. She had amended it, so
We'd
she's
like-
gonna get that out, so.
We'd like to enter the plea and then have the memorandum adjusted as necessary.
Yeah, it looks like, judges in Sheboygan signed it wrong. So we may have to have this
Amended.
redone.
I brought it just for verification that she was accepted into the program, so we could do the plea this morning, and I had written verification of that I could present to the court.
Did you want this back? This is
Yes,
like
thank
an
you, Your
original,
Honor.
So,
I appreciate it.
all right, the only question I have is the plea being entered to the third, and if she's successfully completes the second?
It has to be entered as a second originally. If she's unsuccessful, we can withdraw the plea and switch it to a third, but I think she's gonna be successful and that's the way they do it there. I did ask those questions and that actual answer, so.
All right, Ms. Sunday, have you had an adequate opportunity to talk about this agreement with your attorney?
Yes,
Is that how you wanted to proceed today?
yes, Your Honor.
Raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Ms. Sunday, are you currently on any kind of probation or parole?
No, sir.
You understand that if you were to not successfully complete the sobriety court program, that you could be subject to the maximum penalty for a OWI second, which is up to 1 year in jail. You understand that?
Yes, Your Honor.
With that in mind, what is your plea charge?
I'm guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. The right to testify at a trial yourself if you want. You understand all those rights.
Yes, Your Honor.
And you understand that you're going to be giving up and waiving all those rights.
Yes, sir.
Has anybody threatened you with it?
No, Your Honor.
Has anybody threatened you with anything to get you to enter this plea today? Has anybody promised you anything?
No, sir.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty?
Yes, Your Honor.
The information I have indicates this happened back on February 9th of 2025. Is that the correct day?
Yes, Your Honor.
On that day, had you been consuming alcohol?
Yes, sir.
After consuming alcohol, did you operate a motor vehicle on County Road 612 here in Crawford County?
Yes, Your Honor.
Did you have any blood or breath tests determine the level of alcohol in your system?
Yes, sir.
Do you know what that was?
0.19.
Okay. Do you have any reason to doubt the accuracy of that test?
No, sir.
Had you consumed enough alcohol that you believe that your ability to operate that vehicle normally and safely was impaired?
Yes, sir.
Had you consumed enough alcohol that you believe you were intoxicated at that?
Yes, Your Honor.
Had you previously been convicted of operating while intoxicated in November of 2021 in the 91st District Court?
Yes, sir.
Ms. Polk, are you satisfied with the factual basis?
Yes.
Ms. Polk?
I am satisfied, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
I am not, Your
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule?
Honor.
Yes, Your Honor.
On Sunday, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support the finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney between now and then. You're going to meet with the probation officer briefly here today to set up sentencing review. Do you have any questions?
No, sir.
Thank you. That's all.
Thank you, Your Honor. Thank you, Your Honor. Thank you, sir.
Even, these are so confusing. These are so confusing.
Let's go back. So. Asking about this status here.
She is lodged in the Roscommon County Jail, Your Honor.
Okay.
And Mr. Harris is lodged in Arizona, I think, right?
So it's
Yep.
like 6:45, 7 o'clock there now.
Yeah.
Well, Mr. Trombley, he's at 10:15.
I'm not sure. That's an arraignment. I think it's arraignment, sorry.
When someone gets here. Anyone.
So to be clear, I was here. I was
Ross Common?
far when I was late.
Ross Common is having issues with their Zoom. They're trying to get logged in. They've been working on it. So I just got a message.
When I was late, I was very late. Whatever.
All right, Mr. Trush, we're still waiting on Roscommon. Apparently they got issues with their technology over there, so.
Okay, I was gonna make the court aware. I was able to get in touch with their jail and they said that they would work on getting him on, so.
All right, so I'm gonna go off the record for the moment and we'll come back on once we have.
Sure.
We found Roscommon.
Okay.
We give you this deck because who knows who's getting put on.
Okay.
Sir, there in Roscommon, can you tell me your name, please?
Daniel Cyan.
Okay. All right, we'll go on the record and People versus Cyan. This is file number 255468. The record should reflect Mr. Cyan's appearing today by video from Roscommon Jail. If I could have counsel for your appearance.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Cyan.
Okay, Mr. Trush, I do have a copy of a police report here. So I'm assuming your client's going to enter a no contest plea. Is that correct?
That is correct, and it's great news that you have received that.
Can you tell me the terms of the plea agreement?
Yes, Your Honor. He would be tendering a no contest plea to delivery of a narcotic less than 25 grams as a habitual second offender. The principal counts would be dismissed. The basis for the no contest plea is civil liability. I'm not aware of it or involved in it, but I think there may be civil forfeiture issues, and certainly if there aren't, there could be.
Okay. Ms. Cope, do you have any objection to the no contest plea?
No, it's delivery less than 50 grams. That's the first step in it. It's 25 grams for possession, but 50 grams for delivery. It's the same set of drugs.
What's the maximum possible
I think it's 20 years.
It's a 20-year with the HAB 2 would ultimately make the tail 30.
Okay,
And it's 333.74012A4. Grid.
all right, Mr. Cyan, have you had an adequate opportunity to speak with your attorney, Mr. Trush, about this plea agreement?
Yes, Your Honor.
Were you able to hear what the lawyer said about the terms of that agreement?
Yes, Your Honor.
Okay. Did you want to go forward with that today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Cyan, are you currently on any kind of probation or parole?
Yes, Your Honor.
All right. Is this plea today going to result in a violation of your probation?
Yes, Your Honor.
All right. So you're aware that you may face additional penalties for violating that probation by entering this plea today?
Yes, Your Honor.
And then, as the lawyers indicated, the maximum possible penalty you could face for this charge would be up to 30 years in jail or prison. Do you understand that?
Yes, Your Honor.
With all of that in mind, what is your plea to that charge today?
No contender, Your Honor.
Okay. Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Or I'm sorry, by pleading no contest. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anybody promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your
Honor. One other thing I forgot to advise you of, Mr. Cyan, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Okay. Police report in this case is Grayling Police Report number 25-691. Ms. Koch, have you reviewed that report?
Yes.
Do you agree that the information contained within that report would form a basis for a finding of guilt?
I do.
Mr. Trush, have you been able to review that report?
Yes, Your Honor.
Would you agree that the information in that report would establish a factual basis for a finding of guilt?
I would, Your Honor.
Okay. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush, are you?
I'm aware of none, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Trush?
Yes, Your Honor.
Mr. Cyan, the court finds that your plea is knowing and voluntary. I'm going to mark that police report that I just identified as Court Exhibit 1 and admit that to the file. I've reviewed that. I find that the information contained within that report would support a finding that you are guilty. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, somebody from our probation department will be in touch with you for a pre-sentence report. Are you under sentence there in Roscommon County?
No, Your Honor, they were waiting to see what happened with this matter.
Okay. You do have the right to be transported here to Crawford County to have that sentencing hearing in person. You know, are you still gonna be lodged in Roscommon for a period of time after this hearing today?
Yes, Your Honor.
Okay. Did you want to be transported here to Crawford County to have that sentencing hearing in person?
No, Your Honor.
Okay, so we'll set this for a video sentencing from Roscommon County. And again, Mr. Sayan, you'll be notified of the date and time of that hearing. Mr. Sayan, did you have any questions at all?
None that I can think of, Your Honor.
Okay, that's all for this hearing today then. If you can let the corrections officers know that we need them to bring Sandra Stead into that room that you're in so we can do a video hearing.
We will do. Thank you, Your Honor.
All right, thank you.
There's out in the lobby.
And he has a special,
Oh, Mr. Seeger's appearing that day.
and there's a special prosecutor. It's scheduled at 11.
Okay, so we can take that.
Are we done?
Yeah, I'm all set.
I just,
Just gonna say, hey.
Almost like they're using somebody's phone. If there are issues with their system.
Ms. Hope, can you? Your assistant call them again.
Okay.
No Arizona yet.
They haven't had breakfast yet.
All right, ma'am, are you Sandra Stead?
Yes.
Okay. All right, we're on the record in People versus Sandra Stead, file number 255495. The record should reflect Ms. Stead appearing today by video from Common Jail. If I could have counsel for your appearance.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, Sandra Stead.
All right, this is set for a, excuse me, status conference today. Mr. Thompson, can you tell me the status of this file?
Yes, Your Honor. There is a plea offer on this matter. If Ms. Stead pled guilty to count 1, possession of methamphetamine, the prosecutor agreed to dismiss counts 2, 3, 4, as well as the
Drug double.
potential enhancement. So it would be a 10-year maximum for possession of methamphetamine.
So is that a correct statement?
It is, and we did agree to dismiss the drug double. I know she has a pending case in Roscommon. I think we had adjourned it so she could work on that case. It's not going to change the offer, but that is our offer.
Yeah, it's my understanding she's pleading in Roscommon, so we just asked to get the sentencing as close to their sentencing as we could.
Okay. All right. Ms. Stead, were you able to hear what the lawyer said about the plea agreement?
Yes.
Have you had an adequate opportunity to speak with your lawyer about that agreement?
Yes.
Is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can lower your hand. Ms. Stead, are you currently on any kind of probation or parole?
No.
You understand that the maximum possible penalty you could face for this charge, which is possession of methamphetamine, is up to 10 years and or a $15,000 fine.
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said on the record?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates that this happened back on April 30th of 2025. Is that the correct day?
No.
Okay, what was the date to your recollection?
May 22nd.
Okay. On May 22nd, were you present here in Crawford County?
No, actually, I was here in the Roscommon County Jail.
All right, well, the charge in this case alleges, again, I'm using April 30th. It alleges that on April 30th, you were here in Crawford County and you had possession of some methamphetamine.
No, I didn't. It was all the same day as the day I came in here, and then they searched my room the day they arrested me and put me in here, and then they went and searched my room that next day. And that was in May.
Okay, was your
That was
room
May
located,
21st. I came in here and
what, on that day in May, was your?
my room is located in Crawford County, yes, but on that day, no, I did not have methamphetamine on my possession. It wasn't until May.
Okay, all right. That's fine. So in May, the police did a search of your room here in Crawford County.
Yes,
And during that search, they found methamphetamine.
yes,
Was that your methamphetamine?
yes,
Okay. Did you have any legal right to have that methamphetamine?
no,
Ms. Koch, are the people satisfied with the factual basis?
Yes.
Mr. Thompson?
Yes.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute, court rule, and the taking of this plea?
Yes.
Yes.
Thank you. Ms. Stead, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied based on your statements that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Between now and then, you'll be, someone from the probation department will be in touch with you for a pre-sentence report. Mr. Thompson, based on your arrest common matters, should we set that? When do we need to set this for?
Ms. Stead, do you know your date for your arrest common sentencing?
as of right now, it is January 13th. There is a possibility it be pushed out to February, but yes, as of right now, it's January 13th.
So I guess we should try to get close to that date.
All right. Okay, so we could set it for January 8th. And Ms. Stead, did you have the right to have your sentencing hearing on this Crawford County charge here in Crawford County? And if you wanted to exercise that right, I would sign an order to have you transported here for the purposes of that hearing. You can waive that right and we can do it by video like we're doing today. Do you know how you'd like to proceed?
Yeah, that's fine. I'm okay with that.
By video?
Yeah,
Okay, so we'll set this as a sentencing by Zoom from Roscommon County. That's all for the hearing today. Ms. Stead, do you have any questions at all?
no, I don't think so.
Okay, thank you. We're going to disconnect at this time.
Thank you.
Mr. Trombley, you want to come up to the podium, please? This is People versus Sean Trombley, right up to the podium, sir. This is file number 235197. Reflect Mr. Trombley present here in the courtroom today. This is set for a probation violation hearing, I believe.
Yes, Your Honor.
Okay. And Mr. Thompson, how do we want to proceed today?
Well, in speaking with Mr. Trombley today, he was asking if the court would consider adjournment. He advises he's very ill. He certainly appears ill to be. He also advises he has a funeral tomorrow for his maternal grandmother that's down at Ferndale. I'm sure the prosecutor has their witness today, so I don't know if there's any prejudice to adjourning this.
Ms. Coker, Mr. Avery.
Your Honor, I don't have any objection. I was just informed that he is going to be charged criminally for actions related to the violation, so an adjournment would be appropriate.
Well, I was not yet aware of that, but I would add that to my research. That would be appropriate.
All right,
It was just a
I'm
value.
going to adjourn this out 60 days then, and then we'll see where we're at the underlying charges. So Mr. Trombley, just make sure that you stay in touch with your attorney, okay? All right, thank you, that's all. Thank you.
Feel better.
Mr. Witt.
He is, if I could just have a couple minutes with him, Your Honor. Thank you.
Oh, you just use hand sanitizer. I was like, what is that smell of
Yeah, that's-
alcohol?
That's, boy.
Sir, are you here for court?
Yes.
I'm here to watch a friend.
Okay.
Mr. Harris, we are gonna get started with your hearing in just a minute. So I just want you to remain, on the, connected on the video, okay?
Okay.
But it may be another 5 minutes or so, so I'm gonna put you back on hold, but I just wanted to let you know that, we have your case. It's gonna be coming up here in just a minute.
Sounds good.
Short recess and we'll come back on the record.
Your Honor, thank you.
Mr. Witt, if you come forward, please. We'll go on the record, People versus Jonathan Witt. This is file number 255480. The record to reflect that Mr. Witt is present here in the courtroom today. This is the date and time set for sentencing. Mr. Witt, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections?
No, Your Honor, thank you.
Are there any challenges to the report?
No.
Any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this point?
No, Your Honor.
Anything on behalf of the people for allocution today?
You know, this is one of those anomalies where you see somebody who's 36 years old with no criminal history, no juvenile history, no misdemeanors, really no interaction with law enforcement at all throughout his life, and then makes a bad situation of, you know, drinking and driving at a .214 into something much worse by his own behavior. I hope that he takes it seriously. I think the recommendation is appropriate, and I hope that we don't see him again. Thank you.
I agree, Your Honor. I obviously working held that evening he behaved badly, and he's very ashamed that he regrets it very much. I think the court does have to put it in the proper context, which is 36 years old, good job, sterling track record, no problems with law enforcement, no issues. He got drunk that day and made him an idiot, and it was idiotic to be driving at a .214, and then it was idiotic to be not immediately complying with the police, and that's on him. That's the mistake he made. I do want to just put in context for the court. He had a surgery just a couple weeks earlier. He's got a problem with his bone on his hand. It's got him off work, caused that surgery. When he was being an idiot and he was not immediately complying with police officers and they started to restrain him, they caused him a lot of pain by the way they were restraining him, because he had just recently had a surgery on his hand. And I think that's part of why after that he did, you know, kind of react physically. But he put himself in that circumstance, Your Honor. So I don't want you to think I'm trying to blame police officers or anything like that. I am trying to explain part of what happened that day was he did experience a lot of pain in his hand where the officers wouldn't have known that that would have been such a sensitive spot for him. Having said that, Your Honor, having said that he acted inappropriately that day, I hope none of us get judged solely on the worst day of our life. And for a 36-year-old guy, you know, I think this can end up being more of a wake-up call for him. I think this can end up being the worst day of his life and something he improves from. I did want to sort of follow up in the substance use and treatment part of this report. It states that he told the probation officer he didn't think he had a drinking problem. I've talked to him some more. I don't think that's what he would say today, and I don't think that's accurate. And what I tell a lot of my clients is, you know, you can debate about the semantics, but you have a problem, and it's from when you were drinking. So you have a drinking problem as far as I'm concerned. I mean, he's got a huge problem. He's before a circuit court judge today. He's got a huge problem in his life now, and it was caused by his drinking. So he understands that's a drinking problem. That's a problem in his life from drinking, and drinking, you know, objectively too much, 3 to 4 times a week is too much to drink. Being at a .214 while you're driving is objectively drinking way too much. So he now has, it's now right in front of him. And he sees that, and he's taking that seriously. And he is going to AA, and he's given me this AA sheet, Your Honor, as he's trying to come to grips with and learn about what's happened to his life and what could happen if he doesn't arrest and change this. So he got put on bond conditions to not drink alcohol. He's not drinking alcohol. He's learning a lot. I don't think he's all the way through recovery. Certainly the court talks to people who've been to rehab 6 times and they, you know all the language real well. He doesn't know all the language real well, but he knows he has a problem, and he knows he needs to face consequences today and own up to it. And he knows he needs to use this as a learning opportunity to not have this happen again, not put himself in such a terrible position because he acted so stupidly. And he does want to apologize to the court. He regrets what happened. Again, this is a guy with a good job, with really good family support. I think he'd be an excellent candidate for probation to do well. And this might be a situation where the court could hold his jail time in abeyance because he's gonna let us know how he's gonna do. He's gonna be under a microscope. He's gonna have to be sober. He's gonna have probation officers and people watching him. And if he can turn this thing around, Your Honor, I think that we can chalk this up as, you know, thank God nobody was hurt. Thank God it wasn't worse, and maybe he learns from it. And if he doesn't, then, you know, the court's got all kinds of sanctions they can impose on him. So ask the court to consider jail time in advance, consider probation on this matter. Thank you.
All right, thank you. Mr. Witt, anything that you wanted to say?
Yes, I just want to start off by apologizing to the city of Grayling, everybody, the officers, you guys here, putting everybody in this state on the way up in jeopardy because I was drinking and driving on the way. And I drank a lot before I got in the car, before I came up here. You know, I drank on the way up. I shouldn't have been doing shots on the way up. It's just a terrible idea. I mean, you know, it's just one thing led to another. I don't think my attitude was very good. You know, going to AA, I've kind of learned a lot more about me and drinking and everything else, you know, being away from alcohol. You know, I definitely learned that I've calmed down quite a bit. You know, I've been so wound up. I haven't been working because my hand's been injured. And, you know, I just, you know, it's kind of, that drinking thing has been getting out of control. I chose to make a poor decision. I made more bad decisions with everything. You know, I just wanted to say, or I just want to apologize to everybody. You know, I made a mistake. I own up to it. And, you know, I'm sorry.
Read through the report, so I'm familiar with you, your background, your circumstances generally, as well as the details of what happened during this incident. Yeah, I think Mr. Thompson summed it up really well, and we've indicated it as well that, you know, it's probably something that's been coming maybe for a while, and this all came to a head on this particular day. Certainly, the court has concerns about public safety. You indicated yourself, you really did put everybody in danger, including yourself, by driving in the condition you were in. That's an incredibly high blood alcohol level, operating what is basically a bullet going 55 or 60 miles an hour, and it's just by sheer luck. And I'm glad to hear that you are getting some treatment, that you're taking this seriously. You're going to AA. And it sounds like you're discovering maybe some things that maybe this has been a problem for a while. You just didn't see it as that. This has made it more apparent. So getting help with that is going to be really important for you going forward to avoid having more trouble, to move on from this instead of this being like the first time with many. That's not what you want. Certainly not what we want as a community.
No, I definitely would like to be my last time.
Yeah.
I'm gonna make it my last time.
Getting involved in AA, getting some therapy, some help. It's the kind of things that are going to prevent it from happening again. They're not fun to do. It's not a pleasant thing, but you're going to have a better way to do that. In terms of the resolution of this, you know, based on your employment, your individual circumstances, I don't think that probation is a good option here. Regardless of the probation, I do think that a short jail sentence is appropriate as a punishment, as a deterrent, so that you understand that this is just not acceptable behavior and there's a consequence to that. The guidelines here are 0 to 9 months, so the court could sentence you to up to 9 months in jail. I don't think that's appropriate, given the factors that Mr. Thompson outlined, your lack of prior history, and so forth. And that's why I think the recommendation here is well crafted. It provides a degree of punishment for you, and again, hopefully deterrence, so that a stay in jail is going to really drive home the point that this is not the direction that you want to go in your life. So the court is going to sentence you to the Crawford County Jail for a period of 30 days. You have credit for 2 days served. It's going to order restitution in the amount of $240.98. That's payable to the Crawford County Clerk to be dispersed to the Crawford County Sheriff's Department. Crime victims assessment of $130, court cost of $325, attorney fees of $350. No UIL testing reimbursement of $150. DNA testing fee $60 and $118 state costs. That as to both counts 1 and 2 to be served to each other. Mr. Thompson, was there something else to address?
I was just checking to make sure we had 2 days credit.
Yes, 2 days credit. You do have the ability to seek an appeal of the sentence, Mr. Witt, Mr. Thompson, if you can, Mr. Witt, now.
Thank you. So Mr. Witt, if you initially hear that's not filing an appeal, but it's saying you received these papers, you're going to keep 2 copies. If you wanted to file an appeal, you would use these 2 copies, you would fill them out. You have 14 days to do that. You can take those with you. You're going to end up going with Steve here, okay?
Am I going to jail right now?
Yes.
Is there any chance I may be able to change?
We're going to have to go with the officer to help you. Mr. Daniel, were you ready on Mr. Pritchard's case?
Yes, Your Honor.
Oh, actually, before that, Mr. Vernon, are you?
Ready, Mr. Harris?
Okay.
I'm ready all of them. I think it's just only been waiting on.
Let's take Mr. Harris. Mr. Harris, are you able to hear me okay?
Yes.
We're on the record in People versus Timothy Harris. This is file number 255452. The record should reflect that Mr. Harris is present by video from Arizona. Executive counsel for your appearances on.
Sierra Cook on behalf of the people.
Adam Bird on behalf of Mr. Harris, who was the court identified as appearing by way of Zoom.
Thank you. This is the date and time for sentencing this matter. Mr. Vernon, have you been able to make contact with Mr. Harris?
Yes. I did, Your Honor. We had an opportunity to review the PSI. There are no additional solutions or corrections to the report. And there are no challenges to scoring.
Okay. Mr. Harris, did you have an adequate opportunity to talk to Mr. Vernon about the pre-sentence report?
Yes, Your Honor.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Anything on, do you have any challenges to this form?
No.
Anything on behalf of the people for allocution today?
Yeah, this is an odd recommendation, given his guidelines are 19 to 38, and it's below the guidelines. Given his criminal history, that would normally be very odd. But the way his sentence is structured in Arizona, he's going to go through that, I think it's prison program, and then have a several years of post-prison program. It wouldn't make sense for him to come back here and then go to our prison system. It just would be a logistical nightmare because he's not scheduled to be out of Arizona until August 2027. So I did talk to MDOC about this recommendation. I think given his circumstances and what's happening with his cases in Arizona, I think it's appropriate. I'd ask the court to follow it.
Thank you. Mr. Vernon?
We are likewise going to ask the court to adopt the recommendation. Consistent with what the PSI and Ms. Koch have identified, Mr. Harris is going to be incarcerated for quite a lengthy period of time. Not sure what authority or what discretion the court has in some of these fees, but it's going to be a great deal of time before Mr. Harris has any ability to repay any of these fines and costs. Would ask the court to consider, to the extent that it can, waiving those costs or giving them additional time to pay them. Other than that, we'd simply ask the court to follow the recommendation.
All right, thank you. Mr. Harris, was there anything that you wanted to say today prior to sentencing?
No, Your Honor.
All right, Mr. Harris, I did review the pre-sentence report, so I'm familiar with your background and circumstances personally. There's also information in that report about the circumstances that bring you before the court here today, the details of your criminal activity here in Michigan. Looking at the circumstances as a whole, including the time that you're serving in Arizona, as well as the costs of imposing a prison sentence here in Michigan, the court finds that, you know, first of all, I think it would be really just further victimizing this community because of the cost of the taxpayers. Second of all, I think that the punishment that you're going to receive as part of your Arizona sentence is largely going to subsume the punishment that you would receive here from a legal standpoint in Michigan. And so given the minimal amount of punishment and consequence that I would really be able to impose upon you here in Michigan in relation to the cost of the taxpayers, I don't see that it benefits our community. I don't see that it serves the ends of justice to sentence you to a prison sentence here in Michigan when in all reality, you're not going to really serve much, if any, time here in Michigan, given your current status in Arizona. So for all of those reasons, I find that the recommendation is appropriate. It makes sense and it's well crafted. So the court is going to sentence you to 12 months here in the Crawford County Jail. That is a downward departure, but again, I'm parting downward for the reasons I've stated. You do have credit for 0 days. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. I appreciate the request, but to the extent that the court can recoup as much, if any, of the financial burden that's been placed on our community by Mr. Harris's actions, I'm going to at least try to do that. So that is the sentence of the court. Mr. Harris, if you haven't already received it, you will be provided with your appellate rights. You do have the ability to seek an appeal of this sentence. Those papers will explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Those, again, will be provided to you there in Arizona. And the timelines for filing an appeal won't start running till you actually receive them. So to the extent that there's a delay in you receiving those, it will not impact your rights to seek an appeal. Mr. Harris, did you have any questions?
No, Your Honor.
Okay. Mr. Vernon.
We did email the advice of rights and appellate review to Mr. Harris today. I don't know if you have you received those yet, Mr. Harris?
The PSI?
No, the email we sent you this morning with regard to your appellate rights?
No, sir.
Okay, and we will, I don't know if the court, how the court wants us to handle filing a notice of receipt.
Typically, I give those to Mr. Vernon's office. They will get it to him, whether it's email, mail, they'll return it back to the law office, and then it usually gets back to me whenever it gets here.
Okay, so Mr. Harris, understand that you have to sign that document and have them send that back to us?
Okay.
All right, thank you.
Mr. Johnson, this is for Mr.
Oh, I'm sorry.
He wants that back. It looks like it's.
Yeah, I don't need it appended to the DSI, so. Other than that, I have nothing else, John.
Okay, thank you. Mr. Harris, that's all for today, and you're free to disconnect at this time.
Okay, thank you, Your Honor.
I'm sorry. I think I'm gonna need to print out something for the next plea. So if I just have a few more moments.
Sure. All right, Mr. Daniel, we're ready with Mr. Pritchard's case.
Yes, Your Honor.
We'll go on the record in People versus Pritchard, file number 255461. The record should reflect that Mr. Pritchard is present here in the courtroom today. This is the date and time set for a sentencing hearing in this matter. If I could have counsel for your appearances on.
Sierra Coke on behalf of the people.
And Troy again, Your Honor, appearing on behalf of Mr. Kurt Pritchard, who's standing to my left.
Mr. Pritchard, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Daniel about that?
I have, Your Honor.
Okay. Mr. Daniel, are there any additions, deletions, or corrections to that report?
Just one minor correction, Your Honor. The page 1 subsequent to the recommendation page, at the top paragraph on the evaluation plan, second line, it says that Mr. Fritcher has pled to operating while intoxicated third offense. Technically, he pled to operating while visibly impaired third offense. It's a slight distinction, and it made a difference at his license sanctions, actually. His prior was so long ago that it was treated as a first offense, impaired driving versus a OWI, which has a different license suspension period. So anyway, it's a minor, that's the only error I found, Your Honor.
Any objection to that change?
No, he's correct.
Any challenges to the scoring, Mr. Daniel?
No, Your Honor.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, it is scored properly.
Anything on behalf of the people for allocation today?
Mr. Fritcher's guidelines are low. They're 0 to 6. The reason they're low is because there's a 10-year gap. He presents at 66 years old with 5 felonies, 6 prior misdemeanors, and a juvenile record. But to his credit, he has not had any interaction with the criminal justice system since his operating while intoxicated third offense in 2008. In this case, it involved him flipping his truck at a .185. He's lucky to be with us here today and not hurting himself or others. He's 66 years old, definitely old enough to know better. Most of his criminal history comes from when he was in his youth. I think they were in the 70s. In fact, I think the recommendation is appropriate. Normally, I wouldn't agree with that type of a recommendation, this being his 4th OWI offense in his life. But like I said, it's been 17 years since he's had any interaction with the criminal justice system. Thank you.
Mr. Daniel.
Thank you, Your Honor. As noted in the court received a copy of a pretrial supervision report that Mr. Fritcher did contact them immediately upon release from jail, that he's been 100% compliant with his check-ins. He did his first 60 days of daily PBTs, and then he voluntarily continued on with that. He's up until just yesterday. So he's been doing voluntary PBTs the whole time. Well, after the first 60 days, the first 60 days were required. Also, that he's attended AA meetings once or twice a day, almost every single day since the incident, June 13th. He actually has a couple of fellows here, 3 fellows there who are his support people from AA meetings. They're here to support him. Again, he's since his plea on November 6th, he hasn't missed an AA meeting except last Sunday they were closed because the power went out. But otherwise, he's been attending his AA meetings on a regular basis. Additionally, he got a substance abuse evaluation from the Grace Center, and he's been counseling with them twice a month. Also, Mr. Fritcher does realize that he's an alcoholic. He has a past history. He's been out of trouble since 2009. And he's had prior history for drinking and driving. He understands that now, obviously, it's been a little later than it should have been, but he understands now that he can no longer drink alcohol, that he is an alcoholic, and he knows that he needs to, maintain his sobriety the rest of his life. He knows what he did was wrong, and through his actions, he put himself at risk, and he knows that he deserves to be punished. However, his conduct, he's demonstrated since his arrest, he's taken all the militia steps. Again, he's voluntarily doing a preliminary breath tests. He's going to counseling. He's going to AA. He's put himself in a good position here to avoid being a repeat offender, Your Honor, and ask the court to take that consideration. Another recommendation is at 60 days, ask the court just to consider 30 days, but 30 days be held in abeyance pending successful completion of probation, Your Honor. Thank you.
Thank you. Excuse me, Mr. Fritcher, was there anything you wanted to say?
Yes, first I'd like to apologize to the community, the Grayling community, for my actions. They're unacceptable. I do realize that I have an alcohol problem, and I'm trying to address that in a stringent manner. I've got a good support group behind me in the program. I was in the program years ago. Sponsor died. I ended up drifting away and ended up going back into drinking, and it just got worse and worse. And I'm ready to admit that I do have a problem with alcoholism and that needs to be addressed. And trying to keep myself in a positive, forward manner to be able to recover from this and not drink. And again, my apologies to the community for my actions. Like the prosecutor said, that, I'm still alive and I'm glad that I didn't hurt anybody else.
I did read through the report. I'm familiar with your background and your circumstances, generally based on the information in that report. I'm also familiar with what happened in this particular case, based on the recitation of the police report that's in there. So I feel like I've got a good handle on your situation overall, including your actions in this case. I think there are certainly some positives here. Number one, the fact that you did go for 17 years without any contacts. You managed to move on from what does appear to be some problems in your early life. And for a sustained period of time, did not have any involvement. That's absolutely positive, because what that shows the court is that there's potential for rehabilitation from this incident, that you go back to the way you have been for 17 years. I think the fact that you are getting involved in AA recovery community, that you're taking it seriously, is also a positive. Again, that shows the court that there's potential for rehabilitation here. I think, your situation is a really striking example of how alcoholism is a lifelong battle. You can go for as long as you did without any contacts. Not that you weren't drinking through all of that period of time, but how, you can have problems, be okay for a long time, and then the problems just start right up again. And so I hope that that's something that you look at as proven evidence that you just cannot go back to drink for the rest of your life, and that it is going to be a lifelong battle.
It is.
And I think the fact that you're looking at it that way is a positive, again, because I think that's shows the court that there's the potential for rehabilitation. Obviously, on the downside, this is your fourth time, down this road of alcohol-related driving offenses. That is a concern to the court. Part of what I have to look at is protecting the community. I'm well familiar with Wilcox Bridge Road. I drive that road all the time. There's pretty nasty curves there, not curves that I would want to try to navigate with the kind of blood alcohol level that you had. I think you're extremely lucky that you weren't more seriously injured or killed. And the other driver that you encountered, I think, is really lucky that this is the worst you could be here under much different circumstances right now. So that is a concern. And your actions in engaging in this, again, for the fourth time, I think warrant a degree of punishment. I think the recommendation is well crafted to address all aspects that I've mentioned. I think a period of probation, make sure that you stay on the right track with supervision for a period of time is appropriate. And I think probation also acknowledges the potential for rehabilitation. I think the guidelines are 0 to 6 months. I think a sentence at the low end of the guidelines is appropriate to address the punishment aspect of this and the deterrent aspect of this that I mentioned as well. So for all of those reasons, I'm going to follow the recommendation in the report, and that is to sentence you to probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 60 days in the Crawford County Jail with credit for 1 day served. The court is going to order restitution in the amount of $200 to be paid to the Crawford County Clerk to be dispersed to Michigan State Police. Crime victims assessment of $130. Supervision fee of $30 per month while you're on probation. Court costs of $325. OUIL reimbursement fee of $150, $68 state cost. You do have the ability to seek an appeal of this sentence. Mr. Daniel, if you can let me know once Mr. Pritchard
Go ahead and date this, please, and then initial it. This is your appeal rates. Does he sign all three of them, Your Honor?
He is gonna want to do that, as two of them, he is gonna keep, one goes to the prosecutor and one comes to me.
Okay, just put your initials there, please. That's one.
Thank you.
Welcome. All right, here's the 4 copies here, so you keep one. There's an
He
extra one.
keeps two, one to the prosecutor, one to me.
Well, the prosecutor's
I
got
already have
one.
one.
He keeps two.
He keeps 2, okay. Okay, let's do it differently. He has a bag of medications. You allowed to take that in, or somebody's gonna, okay. All right, you all set?
Yes.
All right. Thank you. Thank you, Your Honor. All right, we'll talk to you later. Yeah.
Oh, he's here. Right, Mr. Seeger and Mr. Thompson, we're going to call Mr. Wilson's case. Ms. Goodrich, are you able to hear me okay?
I am. Thank you for letting me attend by Zoom.
Okay, you're welcome. I have both defense attorneys and Mr. Wilson present here in the courtroom. We'll go on the record in People versus Joel Wilson, file number 255421 and 5485. Counsel, defense counsel, put your appearances on specified file for the record.
Thank you, Your Honor. Jason Thompson, I'm the attorney in the Younger case.
Melissa Goodrich, prosecutor on special assignment.
Mr. Thompson's on the insurance fraud, false report, the 5485.
All right, Mr. Seeger, did you want to put your appearance on?
Thomas Seeger appearing with on behalf of Mr. Wilson.
Okay, so this is set for, don't be shy, Mr. Seeger, come out. All right.
He's looking to have his case dismissed, so he doesn't want you to get trapped in here.
They want to get too close to. Okay, so I guess I'll throw this out to both defense counsel. How do we want to proceed?
Mr. Wilson wanted to accept a plea today. I have a written plea offer from Mr. Juliet. I understand he's in trial today. I did text with him on a break and ask if we could do no contest. I do have his text message saying we could, Your Honor. So that's different than the written plea, and I don't know if Ms. Goodrich has been a part of that, because that's just been a brief text message, but we're asking the court to accept the plea offer on a no contest basis.
Mr. Juliet did inform me of that change, so we consent to that.
Okay.
So I have a signed plea sheet. It's not the shortest police report in the world. It's an insurance fraud investigation. If the court accepted that plea agreement, Mr. Seeger's case would be dismissed in full.
Mr. Seeger, is that your understanding?
It is, Your Honor. And just for the record, I've not reviewed any facts with Mr. Thompson's case.
Okay. All right, and so Ms. Goodrich, I just want to make sure that this is clear. Mr. Wilson's going to enter a no contest plea to an added count. I have an amended felony information that indicates an added count 3, but the plea sheet you just handed me, Mr. Thompson, says an added count 6.
might be the wrong case, because that would be Mr. Cedar's case. The plea is supposed to be in 5485, according to the amended felony information that I received yesterday.
Thompson, I just wanted to take a look at this, since you're right here. This is the one that I had. This is the one that you handed me. The one that you handed me was an added count 6 in Mr. Seeger's case. The one that I had before was an added count 3 here.
I'm sorry, one more time.
The one that you handed me today would be for an added count 6 in Mr. Seeger's case.
Oh, okay.
The one that I had,
Yeah, I think that's probably the mistake.
so we just need to make this
That's
one
what
a
you-
no contest.
Yeah, I'm sorry.
That's fine.
I
Just
I
take that one
glanced at
back.
them and I thought they were the same.
Okay.
I got that yesterday by email, but I had this in my file and I'm sorry.
Okay. All right, so Ms. Goodrich, I clarified this with Mr. Thompson. I just want to clarify it with you. So the plea is in file number 255485, and it's going to be no contest to an added count 3 lying to a police officer.
Yes.
Okay. So, Mr. Wilson,
Yes, Your Honor.
have you been able to discuss this plea with Mr. Thompson?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. So, Mr. Wilson, this added count 3 of lying to a police officer, that is a high court misdemeanor that carries with it a maximum possible penalty of up to 2 years and or a $5,000 fine. Do you understand that?
Yes, Your Honor.
Are you currently on any kind of probation or parole?
No, Your Honor.
With that maximum penalty in mind, then what is your plea to that charge?
No contest, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have, sure.
I'm pleading no contest.
Oh, I'm sorry, I misspoke.
I'm sorry, I just caught up.
I get into a pattern of
I apologize
rights.
for
and
interrupting you.
Sometimes I go on automatic pilot.
And Your Honor, just for clarification, and although I didn't review the speech you were saying, there was a small misunderstanding relative to the tenets of it. And again, it's not my file, I'm only indirectly related to it, but at least my understanding is that it would be a delay with the reduction to a misdemeanor, which I'm not sure if the court specifically had indicated to the extent that he successfully completes his the term of the delay, and that was the material portion of the plea.
Right, so is that correct, Mr. Thompson?
Yes.
And Ms. Goodrich, that's your understanding as well?
That is.
Okay, so, yeah, I mean, Mr. Seeger's right, that that kind of sentencing agreement is part of this whole thing. You understand?
Yes, Your Honor.
Okay. And if for some reason I was to not go along with that sentencing agreement, then you would be able to withdraw the plea that you're making here today. You understand that?
I think, yes. If you decided not to agree to it.
Yes.
Okay, yes, yes, Your
And
Honor.
you would not be stuck with the plea you're entering today. You would be able to go back and get all those rights back that you have.
Yes, Your Honor.
All right. So no one's threatened you with anything to get you to plead no contest? Has anybody promised you anything other than what we've talked about today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Your Honor, is there any way Mr. Wilson could sit? He advises he's ill. He's also got a hernia situation.
Sure, yeah, go ahead.
Will that feel better if you sit, Joel?
Yeah.
So, yeah.
All right, Ms. Goodrich, I'm looking at Crawford County Sheriff's Department report number 24120000656. It's dated April 15th of 2024. Have you reviewed that report?
I have not, but I know that Mr. Juliet is aware of that report.
On behalf of the prosecutor's office, would you agree that that report would support a finding of guilt as to lying to a police officer?
Yes, Your Honor.
Mr. Thompson, have you reviewed that report?
I have.
Would you agree that it would provide the factual basis for the edit count 3 here?
I would.
All right. Ms. Goodrich, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Thompson, are you?
No.
Ms. Goodrich, are the people satisfied that the court has complied with statute and court rule in taking this no contest plea?
Yes.
Mr. Thompson?
Yes.
One thing I think I did neglect to do, I'm assuming it's on the basis of civil liability, but is that the basis for the no contest?
It is, Your Honor, in terms of just general civil liability with the insurance company. He's also got a liquor license, so that's a possible civil consequence.
Okay. All right, so Mr. Wilson, the court finds that your plea is knowing and voluntary. I'm satisfied, and I'm going to mark and admit as an exhibit the police report that I referenced in Court Exhibit 1. I find based on the information contained within Court Exhibit 1 that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. In the meantime, you'll meet with somebody from the probation department to set up a pre-sentence report. Mr. Seeger, I don't think you would need to be present at the sentencing hearing since your file's been dismissed.
That's fine, Your Honor, just for clarification, because I'm somewhat unfamiliar with the other office, but I assume there then that ordinarily it would probably be dismissed at the time of sentencing, but because the matter is set for trial, I assume that they'll file a nally. I guess they could reauthorize it later, or if you want to. I'm just trying to kind of find your docket in mind as well. So I know it's a little bit different, but.
So I just texted Mr. Juliet, and because usually I do the nollies in this county, he advised me he already has them done. He is going to send them to me, but those will be presented at the time of sentencing.
I'm going to adjourn the trial date, so typically you're right. I would wait for unless we had an alley, but I think under the circumstances, we can take care of that. So, all right, Ms. Goodrich, anything further we need to address from your side?
No, Your Honor. Thank you.
Mr. Thompson?
Nothing further for today's record.
All right, thank you, Mr. Wilson. Just make sure you stay in touch with your attorney.
All right, so you're going to talk to John now. John Davis. Investigation for you. All right, feel better, Joe. Yeah. Okay. The second person today has told me they're ill, so apparently something's going around.
I just sent an email, just for it take 2 minutes.
The wrong table.
I have to file a brief, so.
Working on it.
Okay.
It'll be done tomorrow.
No stress.
Oh, I got it. Halfway
Mr.
done.
Leland? Right. Mr. Leland, if you come forward, please. Yes, if he's Mr. Woods.
Oh, he's not coming. But, well, I shouldn't say it that way. I have no expectation that my client, Mr. Woods, will appear today.
Okay. All right, well, we'll take that up next. We'll go on the record now. Eric Leland, this is file number 245280. The record should reflect Mr. Leland's present here. Executive counsel with your appearance is done.
Eric Hoke on behalf of the people.
Adam Brown on behalf of Mr. Leland, who's present today, am I right?
Okay, this is set for a status conference today. Mr. Vernon, can you tell me what things are out of this?
So I I will explain what we're going to be asking the court to do is ask for a short adjournment in this matter. Mr. Leland had at the last hearing requested appointment of new counsel. This court advised him that that had to go through MIDC. The statements made on the record were essentially that the court would refer this to Mr. Thompson, the MIDC coordinator. Mr. Leland took no steps to further that action. I contacted Mr. Thompson to see how that process was going, and he had taken no steps because he had not received anything regarding the request for new counsel. We had a couple conversations with court staff in Mr. Thompson's office, and determined that the process was actually that Mr. Leland would have to make that request himself to Mr. Thompson or to Mr. Thompson's office. He made that request. Mr. Thompson's office contacted me early last week with regards to my version of what had happened. We had sent a response to them yesterday. We got a letter from Mr. Trush this morning identifying that the request for new counsel had been denied. It identifies in that letter that he has a right to appeal that decision to this court. I'm not familiar with what that process looks like, as I've never been involved in that process. But I believe Mr. Leland wishes to take advantage of that opportunity and have this court hear that appeal for new counsel. I would identify also that Mr. Leland and I have been struggling to formulate a plan going forward on how best to process his matter. There are certainly some questions that he has that I apparently have not answered satisfactorily. So I would ask the court to at least adjourn until the court hears the appeal on the new counsel issue. If the court's not inclined to do that, we would be asking for an appeal because again, I think Mr. Leland has questions and concerns related to whether the plea is his best course of action at this point.
Okay. All right, Mr. Leland, how do you want to proceed? With the appeal. Okay. All right. Then I guess what I would need you to do, Mr. Leland, is put down in writing. Do you have the ability to do that in the jail? Yes. I would need you to put down in writing the reasons that you believe that the court should replace Mr. Vernon. Are you asking the court to appoint different counsel for you, or did you want to hire your own attorney? Different counsel. Okay. All right. Appointed. Yes. Okay. Mr. Thompson.
I'm not sure how much I should say. So I haven't been part of Mr. Leland's request because I represent his wife, who's his co-defendant. So Mr. Trush has been, but in terms of appeal procedure, you can appeal to a different MIDC administrator. Typically that's Mr. Slough. There's also court rule about the motions to the court about appointing counsel. So I'm not saying that's precluded, but MIDC use of the appeal would suggest it should go to Mr. Slough.
Okay. So, Mr. Leland, what I'd like you to do is submit again to. I'll get that right.
Correct.
Okay. So, submit that the reasons why you believe we should have different counsel appointed, in writing, have the jail get that into the clerk's office, and we won't need to have a hearing. We can make that decision just based on writing. Okay. And then, depending on that decision, we'll set this for another hearing at my next available date so that we can get it resolved one way or the other.
Quick question. So do I write it to, who do I write it to? Can I get a piece of paper that says
To the court.
Just to the court?
Yes. And just as well as you can, put on reasons why the court should. And then court will make a decision, you'll be notified of that decision. And then again, we'll have this set for hearing at the next available dates with your case. Okay. Do you have any questions about that?
Sure.
All right.
I have one, I don't know if it's for Mr. Thompson or for the court, but because Mr. Trush is the one who reviewed and responded to this, I can appoint this counsel if the court grants that request.
I'm not it.
Okay.
Yeah, I think that is that. across that.
Okay.
Whether it be Mr. Trish or whether it be outside.
Thank you.
Yeah. Thank you.
Hold on, I'm gonna give him some blank paper. I don't know if he has it.
You can get it back there, but I can get it.
Okay, all right, Mr. Burns gonna give him some blank paper. The last person said they only had the jail tight and it got really,
Oh.
There's no staples, there's no papers.
I just wanna make sure.
And then let's call Mr. Woods matter. This is People versus Dennis Woods, file number 235201. Council, put your names on that.
Sierra Coke on behalf of the people.
And we're on behalf of Mr. Woods, Your Honor. I indicated earlier that I didn't expect Mr. Woods to show. I've had my staff make 1, 2, 3, 4, 5, 6 separate phone calls to Mr. Woods. We've had no response. We have one phone call to his significant other who we had permission to speak with, trying to get a hold of him through her. No contact, no voicemail, or a voicemail was left at each of those occasions, and no response to any of those. I don't know where he is. I don't know how the court wants to proceed.
Okay. Ms. Coke, unless you have an objection, the court would request a fair bench warrant for Mr. Woods' arrest. The plea was entered in this case back in November. Given the guidelines, which include potential prison time, the recommendation, which is, I understand not necessarily the author's recommendation, but it is 12 months lengthy jail sentence. Mr. Woods does not reside locally. In light of all of those things, and this hearing was set for 11:15. It's now 11:30. Mr. Woods has not appeared before the court. So for all those reasons, I think it's appropriate to consider that Mr. Woods is absconding. So once a bench warrant is prepared and signed and apprehended, the court will sign an order that he be remanded to the Crawford County Jail without bond until the hearing is set for sentencing. Spoke any objection to that?
No, he's failed to appear previously, and then last time he failed to appear, but appeared late, and there's been numerous issues throughout the case. I think that's appropriate. I think he absconded for 2 years.
Thank you. That's all for today. That concludes our morning docket. The court will be in recess until 1:30.
John's spot.
All right.
Yeah.